We do want to begin with that special master ruling. And NBC Justice reporter Ryan Riley, Boston Globe senior opinion writer Kimberly Atkins-Storr, and Chuck Rosenberg, a former U.S. attorney and a former senior FBI official. Ryan, you're on set with me, so we've been talking about this in the break. Walk us through the developments over this weekend for those who are still catching up, and really what real impact this will have on the investigation.
So the biggest part of this, and what was really what people were waiting for, was whether or not that special master was going to be able to look at questions of executive privilege. I think that had this been a more narrow ruling, had she gone on that more narrow path, she could have just said, hey, we're just going to look at attorney-client privilege documents here. And that would really be a small subset of this overall hoard of documents that were stored.
She leaned very heavily in favor of the former president's claims, what he was arguing for.
Essentially, yeah. And the executive privilege claims, I mean, we really are in pretty uncharted waters here, because that's really something that hasn't been done this way before. Usually special masters are only about attorney-client privilege. The most recent example we've seen in history was, in fact, Rudy Giuliani's cell phones when those were seized. And that was a more complicated matter because, of course, Rudy Giuliani was an actual attorney, and he had a lot of clients who had to deal with this. Right. That could have been the path that she'd gone down. But this Trump-appointed judge, chose to make this a lot broader than just looking at attorney-client privilege.
And you can imagine this is going to be a real challenge for both sides to agree to a special master that the judge would select.
Precisely. Yeah, that's going to be a real and someone with top secret security clearance. It's a very narrow category. It's going to be very difficult for them to find someone who both sides are going to agree with.
With the end of this week, Friday being the goal, the date by which she wants to have that process starting to wrap up. I want to get to Chuck really quickly on this. And Chuck, pointing out an excerpt from the judge's ruling. This struck me as I was reading through it. It says the investigation and treatment of a former president is of unique interest to the general public and the country, is served best by an orderly process that promotes the interest and perception of fairness. We heard from Merrick Garland when he spoke to our colleague Lester Holt, basically saying no one's above the law. But it sounds like this federal judge is making sort of unique rules for the former president because of that former post.
Yeah, nobody, Peter, can disagree with what you just read. I mean, we're all interested in justice and fairness. That's fine as far as it goes. But I think you're right. She does seem to be doing something unusual, but it's an unusual case, and we don't normally litigate questions surrounding grand jury investigations and the mishandling of classified information with former presidents. So I understand her instinct to get this exactly right. I think Ryan's reporting is really important, and I want to reiterate a part of it. Special masters, independent, neutral third parties, are typically used in cases in which we have attorney-client privileged information. Whether or not there's any executive privilege that still resides in the former president is in some ways an untested question, but it seems highly, highly unlikely. And so my major concern here, Peter, is that we're just slowing down the process. Now, the government doesn't have to take an appeal. They can just live with it, and that makes some sense to me. But I'm curious to see what the government does.
Yeah, let me ask Kim, if I can, about this. Kim, how much does this, in your view, sort of damage the Justice Department's investigation in the short term? It's certainly a setback. It's specific to the documents, 11,000 plus that they gathered in August last month, hundreds of pages of documents that were marked classified. And how much of this ultimately, I guess, is determined by who that special master is, who they ultimately select?
Yeah, I think, again, I think the point that was made earlier that it has to be someone, it's usually a special master is a former judge, someone else. But if it's a former judge, it's someone who has likely been appointed by a member of one party or another. I think that in this environment may make it more difficult. Plus, someone who has that level of security clearance, that's going to make it a very small universe of folks. But in terms of the overall investigation, it is still ongoing. It's important to note that even if claims of privilege are made, whatever kind, that still does not make it okay to have classified and other sensitive documents outside of where they're supposed to be. That's not an excuse. That's part of the process here. And so what I would like to see is what I'm interested in is what the Justice Department does. They may realize that, hey, let's just get a special master, get them in place, and move forward so that we can continue this investigation at full speed rather than appeal. Because, of course, appealing this, and Chuck is very right, this issue of executive privilege is undecided, and they could end up with an appeal that not only makes it more difficult to do this job, but can have binding precedent for the future. I mean, one thing that I can't understand about this special master to look at executive privilege is, remember, this is different from the January 6th committee. This is the DOJ. They are part of the executive branch. How can executive privilege protect one part of the executive from the other? It's a lot of questions here.
And Chuck, doesn't this sort of get to the issue of obstruction most specifically as it relates to this, right? These are the documents that the former president hadn't turned over. The argument the Justice Department has made really from the start is this guy has no right to any executive privilege claim or attorney-client privilege claim to documents that that weren't his in the first place. He's no longer the president.
Well, that's right. I mean, look, I think the Department of Justice had a very compelling brief for the judge. She went in a different direction. By the way, Peter, I don't see that as nefarious. I just see it as wrong. And I think to Kimberly's point, it may be prudent for the Department of Justice here simply to accede to a bad order and a bad process, because by acceding to it, you get your stuff more quickly.
Moves it along.
By the way, it moves it along, but I also think there's a middle ground too, Peter. There are other possibilities between appealing and not appealing. And one would be for the Department of Justice to go back to the judge and ask her to clarify her order, meaning what aspects of our investigation are on hold pending this review process, and how can we proceed? Because I think her order is not just wrong, but also a little bit unclear. And so it wouldn't surprise me, it wouldn't shock me if the Department of Justice asked for a clarification. By the way, that's what's sort of fun about being a federal prosecutor. You get to problem solve all the time.
Chuck, can I ask one quick last question to you? Top DOJ officials right now, they're weighing in whether to temporarily scale back work in these investigations within the 60 days that lead up to the midterms right now. There's this sort of unwritten rule that sort of forbids overt actions as it relates to candidates that could have an impact on a campaign. The former president is not a candidate for anything right now. Obviously, he is the biggest name in the Republican Party, and a lot of what he does sort of undergirds every decision that's made in that party. Is that of consequence to the DOJ? Will that impact any of the decision-making they make going forward?
Yeah, maybe. So the policy is actually written, but the 60 or 90-day part of it, that is not written. There is no 60-day rule. There is no 90-day rule. There's no post-Labor Day rule. What the policy says is that the Department of Justice cannot take overt investigative steps near the time of an election, and this is important, Peter, for the purpose of interfering in the election. So you can take covert steps, or you can take steps that are not for the purpose of interfering. But to your larger point, Mr. Trump is not on the ballot. So this is a bit of a gray area. Policies usually are ambiguous because they can't account for every possible factual scenario. But I'm confident the department will be mindful of its own policy. It's been this way for many decades now. And I'm also confident they don't want to do anything that would be perceived as interfering in an election.